Is recognized.
Mr. Speaker, I rise in support of H.R. 1621, the Prohibiting Punishment of Acquitted Conduct Act of 2021. The Sixth Amendment of the Constitution ensures that criminal defendants have the right to a trial by jury. This right is so important that our founding fathers preserved it in the Bill of Rights. It is a hallmark of our great country that one of the many things that separates us from other countries is this. Our commitment to trial by jury means we accept the jury's decision whether we agree with it or not. This bill would prohibit federal judges from increasing a defendant's sentence based on conduct for which the defendant had been acquitted by a jury. In 1987, the United States Sentencing Commission established federal sentencing guidelines. These guidelines allow judges to consider conduct that was not formally charged or proven beyond a reasonable doubt at a trial so long as the judge finds the conduct relevant by a preponderance of the evidence. There are numerous examples of this happening. Judges have intervened to overrule the determinations of juries and have handed down harsher sentences after considering conduct for which the defendants have been charged and acquitted. Allowing judges to consider acquitted conduct punishes people for a crime for which they have not been convicted. It is wrong and it violates the spirit of our Bill of Rights. Both Justice Kavanaugh and the late Justice Antonin Scalia recognized the fundamental unfairness of using acquitted conduct at sentencing. Both said it must stop. In 2015, as a judge on the U.S. Court of Appeals for the D.C. Circuit, then Judge Kavanaugh wrote, quote, allowing judges to rely on acquitted or uncharged conduct to impose higher sentences than they otherwise would impose seems a dubious infringement on the rights to due process and to a jury trial, end quote. I agree with Justice Scalia and Justice Kavanaugh. I urge my colleagues to join me in supporting this bill, and I reserve the balance of my time.
Gentleman from Oregon.